your patent sucks because you committed inequitable conduct and now it's unenforceable. My name is Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. If you like this content, please like, follow, and share. When you apply for a U.S. patent, you have a duty of candor to the U.S. Patent and Trademark Office to disclose all information you are aware of that is material to patentability, material to the patentability of your invention. Basically, that means if it's the kind of thing that could negate patentability or support an argument that your invention is not patentable, you better disclose it. If you don't do this and you go to enforce the patent, the accused infringer can assert a defense and a counterclaim that the patent is unenforceable in its entirety because you committed inequitable conduct. Now, just failing to disclose the information alone is not inequitable conduct. Inequitable conduct requires materiality and an intent to deceive. So basically, if the information is such that the Patent Office would not have issued the information but for the lack of disclosure of it, or and if there's evidence of an intent to deceive, which means more than just showing its material, the patent can be rendered unenforceable. And if you file this case and you're in the case and the other party wins on inequitable conduct, that gives them a basis to get attorney's fees from you, the patent holder, even though it was your patent case that you brought in the first place. Now, what information should you look for? There's a few places you got to worry about things. Okay, did you do a prior art search? If you did a prior art search, you want to disclose that information to the Patent Office. And the way the disclosure is typically made is in something called an information disclosure statement, or an IDS. There's a form, like a fillable PDF that you list the references on, and usually you send a little transmittal letter saying with it. But so there's prior art, which patents, published patent applications, journal articles, things from books. Those are some of the most obvious ones. If you did a search, disclose that. If you have foreign counterpart applications and you're getting search reports in from the foreign countries and they tell you about prior art, you're definitely going to want to disclose that to the Patent Office. If you are relying on test results and you don't disclose bad ones that you got, if you go, you know what, I like these results, but I don't like these so much, so let's just go with these. If you conceal the ones that didn't look so good, you can be found to have committed inequitable conduct, and that just happened to somebody. It's happened more than once. That one is more subtle, and it's a little tough because once you do the test, if the results don't come out the way you want them, now you're stuck with the results. And if you don't disclose it, and it comes out in litigation that you didn't disclose it, you can get charged with inequitable conduct and end up having your patent become unenforceable. Commercial products that you're aware of that relate, to what you're trying to claim, that's also the type of thing you're going to want to disclose to the Patent Office. If there's been any sort of claims asserted against you for things like improper inventorship, somebody saying they should have been named as an inventor, you probably want to disclose that stuff as well. So you do need to cast the net widely, and you guys aren't really going to be in the best position to know what's relevant. So just have a good discussion with your patent attorney about all the types of stuff you've done and what exists, so you can be advised on what to disclose, because it's awful if you go to assert the patent and you end up losing and you end up paying attorney's fees. Okay, so I hope that helps to keep you out of trouble, and I hope to see you here soon.